from my right side, and I was cornered from in front of me with Mr. Zeminski, and there were three people right there.
Take a deep breath, Kyle.
That's what I... That's what I run.
We're going to just take time for our break anyway. You can just relax for a minute, sir. We're going to take a break about 10 minutes, and please don't talk about the case during the break. Read, watch, or listen to any account of the trial.
With your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him, with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
You had
in pairs, and I thought there were other people at that car source before I got there.
Well, Dominic, if you're telling us that Dominic Black called you to run 3 blocks down the road to put out a fire at the 63rd Street car source, then you must have known at that moment that there wasn't anyone else down there, right? Why would you need to go if somebody's already down there?
Mr. Black said to me on the phone, hey, they're setting fires at the other car source. I need you to get down there and put out the fires. It must not have, I don't think it, I took it as there's not other people down there.
Why would you need to go?
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any...
The prosecutor in this Rittenhouse trial obviously did not do his due diligence before making the decision to prosecute. This tragedy never would have happened if the government had simply carried out its responsibilities to protect the safety, lives, and property of innocent people.